IPR. The type of IPR that you have to do is an patent. Okay. And the next type is, we call it as copyright. So copyright is it is entirely different from other types of intellectual property, where a copyright it stands on its own. What I mean is you do not need any approval, or you do not need any registration, or you do not need any grant for such type of uh, intellectual property. So what are the types that fall in this copyright? Uh, is your artistic works, or the drawings that you do, or if you go for any poem, writing of any poem, or a story writing, or if you create your own composition, like if you create a music composition, and when you make a movie, and when you sing a song, when you write a song. So all these things, when it is your own imagination, or whether it is your own work, so all these things will come under copyright. And the third one is, we call it as trademark. So this trademark is nothing but it gives an what to say, it gives a status of an uh, a logo. It is the form of a logo, where you can call it as an business trademark, or you can call it as an like in colleges we give uh, the colleges, they apply for a trademark for their name. For example, if you have Bardiyar University, they can apply for a trademark, like the logo that they have for that particular organization or the institution will have a trademark. So all these things will come under trademark. We'll discuss one by one in detail. I'm just giving an introduction. And then the fourth type, we call it as designs. So designs are nothing but when you have a imagination or creation of a design. Let me just say an example. I have a phone stand. So when you create a new design to keep your phone on the table, that would be a design. So for those things, you can go for such design type of applications. And the another type is called a trade secret. Trade secret is nothing but where you have a formula for a product or something, where you don't want to reveal your secret of that formulation. So those things you can protect under the intellectual property called as trade secret. Once you go for a trade secret, it will not be disclosed to anyone. So this will be kept as a secret until you renew your application. For example, I could here is your Coca-Cola formulation. The Coca-Cola formulation, they have gone for a trade secret. Still, we are unable to reveal the secret behind their formulation. And the another type which I have not mentioned here is the one we call it as geographical indicators. So what is this geographical indicators? So this geographic, so all the other types, what we are speaking now, like the patent, copyright, trademark, trade secret, are claimed by an individual or claimed by a single person. Whereas your geographical indications, which shortly we call it as GI, it is actually given to a community or a geographical area. It is given to a locality where all the people who are in that activity can claim this property rights, that intellectual property right. For example, what we could say, take for example, is in Coimbatore. I don't know how many would be familiar with this. Here, the wet grinders in Coimbatore are very famous. So many people around our nation and around in globally, they come over to Coimbatore and they purchase a wet grinder and they take. The reason behind this is the stone that is used in making these wet grinders. It is a special stone that is only available in Coimbatore. So that's the speciality of this Coimbatore. And these wet grinders are protected by geographical indicators. So this geographical indicator of wet grinder, it covers the entire Coimbatore region, where whoever who can register under this production of this wet grinder. They have to register under this geographical indicator, and they can enjoy the rights. So these are the broadly the types that comes under intellectual property. Then this is just a slide that shows you the history of the Patent Act in India. So the first the Patent Act, the Patent Bill was introduced in the year 1967, and the act was passed in 1970. And it was in 1970, and later the act came into existence only in the year 1972. Now almost the second amendment has been done in this act, and yes. When the rest of the world were much ahead forward to our knowledge of intellectual property, we were certainly lacking in many things in intellectual property. Still, when you compare the other developed countries like US, UK, and Australia, still we are well behind in the intellectual property rights, the knowledge that we currently have, or the entire content that we currently have in IPR. We are lagging compared to the other developed countries. The reason is we were not of that is we are not aware of such properties, and people were not worried about the rights that they have for the inventions they have made. So they have not protected the inventions. uh, so what this made is, like, the other people have utilized our property and they have enjoyed the fruits out of that innovation. So one such case is that happened in turmeric. So we all know that turmeric, that is the manjal, it is an indigenous uh, culture that we usually practice in mostly in Tamil Nadu. For it is being used as an anti-inflammatory agent. We all know that, and that we have been using this from our ancestral days. But what happened is when two scientists from US, who are also the origin of India, they visited our country and they came to know about this magic medicine, and they took this to their own nation, that is to US, and they did some preliminary studies on the turmeric, and they filed a patent on turmeric, stating that it is an excellent anti-inflammatory agent. So India was not aware of this filing because it was filed only in US, and we were not aware of this filing, and we kept quiet for few years. It was almost we were not aware of that filing. And in the year 2000, CSIR, they claimed that many of our medicinal plants that are of Indian origin have been explored by US, and many patents have been filed in US. So only this was the start of our the journey of IPR in our country. So prior to 2000, there was not much progress in IPR. So this was the starting point where the entire India, the entire the attorney community, the entire scientist community, they woke up and they stood together to fight against our own indigenous plants. And then a few years back, we filed a case in US stating that this is not an invention that has been made by US people, and we have all the rights to claim that this belongs to our nation, and we have been using this uh, in our traditional medicine from for many years. And at last, it went for the argument went for many years in the US court, and finally we won that case, and the patent has been revoked by the US uh, patent office. Now the turmeric is free, it is not protected by any patent. It is an property of our nation now. So this is just the story that I was talking about. And yes, so we saw about the types of IPR. In broad types, uh, we can classify them as industrial property and copyrights, where the copyrights is different, where the industrial properties are almost different from your copyrights. In the sense, like the industrial property, you need to go and file your invention or file your logo or file your design or to register in the GI board or Geographical Indicators board. Whereas copyrights, you need not go for a registration. However, you have to prove that that is your own property. So that is the only condition that exists for any copyright. If you can prove that this example I made an uh, I wrote a song. If you can prove that this was written by me, then the copyright it all stands on your side. So the copyright, the proving that this was it was first done by you itself means that you hold the copyright. You need not go for any copyright claiming for such copyrights. But nowadays, what the people do is instead of fighting with in the court or going to other problems related to their own creations, they do a copyright filing and they get a copyright stating that that is their copyright. But there has been many cases where the people who have a copyright, it doesn't mean that that copyright belongs to them. In the sense, if someone can prove that this copyright it actually belongs to me, if he can prove, then your copyright will automatically will be cancelled or revoked. So that is the special characteristics these copyrights have. So what is this? So now we will discuss each type of your IPR in detail in some broad sense. Now, a patent is an exclusive right granted for an invention. So you have an invention, you have made an invention. So this patent will protect your invention for a certain period. Protect in the sense, it will protect your formulation, or if it is a product patent, it will protect your product by usage by others. So you can protect by this patent. Only if your patent is granted, you will enjoy those rights. Once your patent is granted, it lasts for 20 years. So usually the life of a patent is 20 years. So for this 20 years, your patent office will ensure that your formulation or your product or your patent application that you have that has been granted is protected. It means that nobody else can use your patent without your knowledge. So you are the sole person for your patent. That is, only you can enjoy the rights that has been given for your patent and nobody else. Say if I need to use others patent, I have to contact him. I have to make my own the fee that he is charging me to use that patent. Then I can use. Only after paying him that amount that he has been quoted in his patent application, I can go for the rights. So it is a patent is a combination of what to say. It is a combination of your invention and the law that is associated with your protection. So it usually holds for 20 years from the date of filing, not from the date of grant. It is from the date of filing. Say I file a patent today. So today is 8th April. So your patent is getting granted 5 years later, say in 2026. It is getting granted in 2026. Then the lifetime of the patent after your grant will be only 15 years and not 20 years, because your patent, that is the 20 years, is counted from the date of filing and not from the date of grant. So from the time of your filing till the grant, almost it will take 4 to 5 years for your patent to get granted. So already you would have lost 4 to 5 years from your 60 year, 20 year tenure. So another 15 years, you will have the rights to enjoy your patent. So what can be patented? So I said it's an invention. You need to have an invention to get patented. But what are the major criteria that look into the patentability? So the first one is novelty. You should be It should be novel when compared to the prior art. In this prior art, in the sense that has been published earlier or that has been revealed earlier in any literature. So the first priormost thing for any patent application is your novelty, and the next is your non-obviousness. There should be an inventive step. Say two scientists are working in the same field. One has done an invention, the other is also doing research in the same area. He should not do the same invention that he has done just by looking into the patent. So that is not an inventive step. There should be an inventive step in your patent to be considered for a grant. And the third one is your industrial application. There should be an industrial application. So the invention without any industrial application, it is not going to be of any use. So there should be some utility of your research in some area, whether it should be in pharmaceutical line, or whether it is used in agriculture, or whether it's used in medicine, or whether it's used for some other environmental protection or some other thing. So there should be a utility for your patent application. So only on these three criteria, your patent examiners will look into, and they will give their comments stating that whether your patent is novel, or whether it has an inventive tip, or whether there is an industrial application related to your patent. So this is the one we were just looking into. So now who can apply for a patent? So any Indian citizen can apply a patent by his own in any of the patent offices in our country. So we have an office at Chennai for the southern region, and we have an office in Mumbai, and we have an office in Kolkata, and we have an office in Delhi. There are 6 to 7 offices for patent. For each region, there is an office, and you can file your application directly in the patent office. So now coming to the invention. So does it mean that whatever I invent, it can be patented? No. There is also a restriction in the type of invention you make, and the type of the output your invention brings in. So that is also considered in your patent filing. So here I will brief you few things that can be patented and that cannot be patented. Now let's discuss on the things that cannot be patented. So when your invention, if it is related to any gambling machine, or a device for house breaking, or it is a biological warfare material, or it is a terminator gene technology, or it is an embryonic stem cell. So for these things, or for these research activities, your patent is not given. That is, when there is an opportunity for others to make whether if they can exploit your research, then such type of research activities are not encouraged by a patent office, and the patent will not be granted. And a mere admixture of any prior formulations. For example, if I say that is two ingredients we could take, the paracetamol and brufen. If we take paracetamol, it is an antipyretic, and brufen is an anti-analgesic. So when we have combination of these two, and if I say that these two, it works extraordinarily compared to the individual combination, no, this is not an invention. So such type of mixing up of your, just mixing of your already existing products or materials are not allowed for patenting, or they are not patentable. And a mere arrangement of your already existing devices. Uh, for example, a bucket fitted with torch. So you have a bucket, you already have a torch. So you're just fitting your torch in the bucket. So this is not an invention. It is just what we can say it is an innovation, but it's not an invention. There is difference between an invention and an innovation. When you think new ideas, that will be an innovation. But when invention comes, your novelty stands first. It should be novel in all the aspects. So for few examples are these, like a bucket fitted with torch, an umbrella with fan, a clock and radio in a single cabinet, a floor mill provided with sieving. So these I have taken from the patents that has been rejected. So these are the ones that has been filed earlier and has been rejected, stating that these are not patentable under the law, that these are just an rearrangement of or duplicates of already existing devices. And the method of agriculture or horticulture, whether it is any method, whether it is an agricultural method or it is an horticultural method. So such type of method patents are not encouraged, or it is not patentable. However, when you go for an equipment for an agricultural purpose, that such things are patentable. But whereas the direct method of agriculturing, or when you say that I want to improve this yield of this crop, such types are not encouraged. So plants or animals in whole or as part other than microorganisms are not patentable. When I say I have discovered a new type of animal, or I have first time I am reporting a new type of plant, such things are not patentable. The reason is they are already existing. It doesn't mean that it is an invention. It is merely an discovery. When you go and find a new plant or a new species in a new area, this is not an invention. It is already existing in that area, and you have just discovered the existence of that plant. So such things are not protected, and patents would not be granted for such activities. And a mathematical method or a business method or an algorithm or a computer program will not be patented. So this will be very interesting. When you say I am writing a computer program, it is not an invention, because a computer program, you are just it can be an innovation. You are just thinking on the language that is already existing for a computer program. You're just you're changing the language, and you're changing the steps, you're changing the process, and you're coming out with an algorithm. So that is not an exact novelty that you can go for an patent granting. So such things like literacy, dramatic, musical, artistic work, or any other artistic creation, including your films and other television productions, will not be patented. Whereas all these things, they will fall under your copyright protection, whereas they cannot be patented. Now this was introduced recently after your turmeric your issue that came with the US. Now the traditional knowledge is already in public domain, and hence they cannot be patented. So whoever is working on medicinal plants, be careful that just saying that this plant has this property, this cannot be patented, because that would be already existing, and the plant is already existing, and you cannot go and say that this is an invention. Whereas when you go for a formulation, say I am using an active principle from 2 to 3 plants. I'm isolating an active principle from plant 1, another active principle from plant 2, and another active principle from plant 3. On these three, on different synergistic activity, it is showing activity for a specific disease, then that can be patented. But the mere plant itself, it cannot be patented. This is just to give you an example of the patents that has been filed in our patent office. Uh, the invention here, it says gravitational permittivity of free space by R. Vel Murugan. So the title itself says that gravitational permittivity of free space by R. Vel Murugan. So what this inventor is trying to state is, he says that the Newton's equation, or the Newton's equation for sound propagation, is entirely wrong. So he has come with a new concept for the Newton law, and he approached the patent office for such patent. So this was obviously this will not be patented because there is not strong evidence for his patent, and this was rejected. And this is to show you an example of the design type of patent. Hope you'll all be would have seen this type of package. Most of you would have used this, and most of you would have seen in television, in ads and other promotions. Like this ID, this the company called ID. They have come up with a few new package for your batter, your idli and dosa batter, and they have claimed a design for this packaging. The packaging alone, it has a design. So this design, they have sought protection. So if you're taking this same design of this pouch and you're using for some other purpose, you cannot do, because it is already protected by the company ID. So it is they say it is an unique transformer pouch. So you can use some for at this time, and again you can ziplock the cover, store in your refrigerator. Again you can reuse whenever it is required. Okay. So this I was talking about the ID batter, like the design, what we call it as the industrial design. The design here means the features of the shape, configuration, pattern, ornament, or the composition of lines and colors applied to your article. It can be any article. It can be an stand, it can be an ornament, it can be a book, or it can be a mechanical apparatus, it can be an equipment. So whatever thing, the grant is given only for your design, only for the external appearance and the shape and the configuration, how you make that design. So it is not given exactly for the purpose it is being used. It is given only for the shape and configuration of the design. So these are a few designs that has got their protection. These are few pharmaceutical products that has obtained designs, and these are few the ornamental things that has obtained designs. Now comes the trademark. So this mark is usually given to any goods or services that needs to show that they have an extraordinary quality in their product or the service they do. So this trademark is usually obtained by an organization who say that this is a unique service that we do for our goods. Such things, for example, we have the TVS, Telco, 555, Lux, Apple. So these are the for the brand names. They go for such trademarks. So it is usually given to a sign, word, letter, or number. So it can be the form of a drawing or picture or an emblem. It can be a color or a combination of colors. It can be a shape of a good. It can be a graphical representation or a packaging, or it can be also a combination of any of these things. Uh, so these are few examples of your trademarks. Like we have wool mark. In the quality of wool, they say it has 100% wool. when you have an wool mark, we can trust that it is 100%. The wool is pure. So in your, if it is registered, you can see the R uh, inside a circle. This says that it is registered and it has a trademark. The trademark is registered. So these are few examples of your well-known trademarks. We have Coca-Cola and we have Godrej and we have GE bulbs. So this comes under trademarks. Now, what is a geographical indication? We shortly call it as GI. It is an indication that identify goods as agricultural goods, natural goods, or manufactured goods as originating in a territory, in a restricted region. So that we call it as an geographical indicator. So few examples of geographical indicator, as we call it as Alfonso, Basmati, the Basmati rice. So Basmati rice is grown only in a specific area, not in the entire region of our country. So these are few examples to show that they have obtained GI for their products. The one is your Kanchipuram silk. The saris, the Kanchipuram silk saris are protected by GI. So what I mean here is whenever you go for any shop to get a Kanchipuram sari, you ask the dealer whether he is registered under GI, because Kanchipuram silk is already protected by GI, and if that person is registered under GI and if he has the GI tag in his shop, it means that the silk is pure. The silk that he's selling is the pure Kanchipuram silk. And similarly, we have your Coimbatore wet grinder, and we have the Tanjavur painting, and we have the Nilagiri tea, which is also protected. And there are other many examples of GIs, and these GIs are really helpful for the agricultural and the manufacturing sector, where there are many duplicates that are coming in order to protect such people. So this GI tag would help the actual manufacturers of the original manufacturers of that product to a great extent. So the final thing that we are going to see in this introductory part is your copyrights. So this copyright, it can be it should be original, and it should be an artistic work that has been done by the person. So it can be a sound recording, or it can be a cinematograph film. It can be an artistic work. It can be any music that you have sing, or if you can sing, you can sing a song, record it, and that is your copyright. That you have to prove that it belongs to you. It has been created by you. So that is the only criteria your copyright has. So this is just an sum up of all the things which we are discussing now. Like what is the difference between your copyright, trademark, and patent? Your patent, it protects your invention, and your trademark, it protects the unique name of a brand, and your copyright, it protects your creative expressions in the form of an literary or dramatic work. So what is the validity? When you compare all the three things, your patent is valid only for 20 years, your trademark is valid for 10 years, and further 10 years you can go for an extension, whereas your copyright is entirely different. This is valid for the lifetime of the author. So whoever is claiming that I have that copyright, so that copyright is with me for my lifetime plus 60 years after my life. So even after my death, my that copyright will exist for another 60 years, stating that you have been copyrighted for that material, or for that the work that you have done. So this will just skip. So this would be interesting to for you to see. I think most of you would have seen this photograph in social media. Like it is an monkey that this photo was taken in the year 2011. Have anyone heard about this issue, this copyright issue? Hello.
Sir,
Uh,
sir,
I want the students to answer to this. Have you heard about this copyright issue previously?
yes, yes.
So, yes. So this issue, it came 3 to 4 years back when the photographer called David Slater. He took this photograph and it was a big issue when it came to the copyright. What happened is this photographer wanted to take a live photograph of an animal, and he went into the forest and he tried to capture animal very closely, but he couldn't. So what he thought is he fixed his camera in a area, and he thought, okay, let me fix some time for the auto capture, and he was behind the screen. So what this monkey did is it came near to the camera. It was wondering what is this instrument like, and it clicked the button and the photograph was taken. Now the issue came like whether the photograph was taken by the photographer or the monkey. And it was an issue that was in social media for many days. And the social, the animal favoring committees and the groups, they told that no, this belongs to the monkey because the photo has been taken by the monkey and not by the photographer. So the copyright has been given to the monkey and not to the photographer. So this issue was there for many years. It was in the court, and but as per our copyright law, it says that the person who is given this copyright, it should be an human. So this all this law, the IPR protection is all done for the human community, not to any other community apart from the humans. So with that statement, they concluded that it cannot be given to an animal which is not an human. And further, in out of the court, these two they discussed, and the photographer came to a settlement that okay, so whatever the earnings that I make through this photograph, when I post this photograph in the social media, the earnings that I make, the 50% I will give to the maintenance of this animal to the maintenance center or the zoo where this animal was there. So till date, 50% of his earning through this photograph goes to this little monkey, the smart monkey we could say, and a lucky monkey who is earning a lot in even in his old days. So this was a big copyright issue that happened a few years back, and it was almost existed for 2 to 3 years in the social media. And this is another issue you might have all heard about this. The issue, the dispute that happened between SPB and Ilayaraja. SPB is no more, and uh, I don't want to dig much into this copyright issue. But this was the issue that came in when Ilayaraja stated that the the composition he has done, the music composition that he has made should not be uh, uh, used by others without his permission. Whereas there is a law that states that the person who holds the copyright for the music, whereas the person who has sung that song, will also have the equal rights to sing this song in public, or uh, uh, he can telecast a song in public or in any orchestra or such troops. So there is also a law, equal law for the singers also. But the issue that came in is SPB has all the copyright rights for the songs he has already the a singer of that song. That is Ilayaraja போட்ட மியூசிக்கு if SPP was the original singer, then he has the rights to sing or perform in other uh, this thing performances. Whereas here he doesn't have rights to sing the songs that has been what to say. The music was Ilayaraja and the singer was someone else. So he doesn't have the rights to sing other song where Ilayaraja was the music director. So that was the issue that was a big fuss between these two, and finally it was resolved. So these are the few offices that I wanted to just show you. That the patent offices, we have four, one in Kolkata, other Delhi, the third one is in Chennai, and the final one is in Mumbai. And the design office, we have only in Kolkata, and the trademark registry we have in Mumbai, the head office at Mumbai, and the offices that accepts patent application will also accept your trademark applications. Finally, they will send to the head office at Mumbai. And GI registry, the head office is in Chennai. And to the students part, I would say that there is a lot of openings that is existing in IPR. These are few companies that are recruiting life science candidates after their degree and post graduation. We have Maxwell IP Services Private Limited, and Promax Legal Solutions, Emerge Tech Global Services, Clarivate Analytics, GQ Life Sciences, Rights and Marks, IP Law, Indian Institute of Patent and Trademarks, Molecular Connections, and here your role will be either as patent analyst or your research analyst. So you can contact me if you need much information on these companies. I'll be happy to share with you. And I will share you the other details where you can do your post-graduation related to IPR and a certificate course that is related to IPR, so that much of such companies will attract you for an offering. So such type of opportunities are picking up in our nation. Many companies are recruiting, especially the science, life science graduates towards this IPR sector, and much more opportunities would be created in future for young people like you. And thank you. And if you have any queries or questions, you can ask me. I thought of sharing another PPT with you. I think it's already too late. Maybe I will have another session. I will discuss with your organizers, and I'll come up with another section where I will highlight more things on the patent search, how to identify that your patent is it falls under the criteria, and what are the databases available, the free online databases where you can go and search and decide that your patent is patentable, and there are no prior arts that are existing in your area. So such things I will cover. I will also cover about the patent application, how to file an application in patent office, and what are the contents that needs to be filled, and what are the forms that has to be used while going for an patent application. And now it's open for discussion.
Thank you, sir.
Thank you, ma'am.
The participants, do you have any queries? You can ask to sir. So, what are the difficulties a person will face when a IPR product is getting converted into a startup?
As far as your startup is concerned, I think you'll not face any difficulties during your earlier startup tenure. What I mean is here, when you're going for a startup, you will have only the idea. The ideation is with you, and you're going for the production of that product. So only in the later stages of your startup, you will have this difficulty where you will have this going for an IPR for your product and for your formulation, such things. So what you have to do is from the day one of your startup, you need to watch the similar products that is coming into market, that is existing. In short, I mean is you have to look into the prior art that is available in your field of research. Only if you have an eye on uh, the IP world, you'll able to understand that okay, what I'm going and what I'm doing is in the right path. So only at the end you shouldn't feel that oh I have invested so much of money in this research. I have spent almost 2 to 3 years as a startup to bring up this product. Now at the last I came to know that there is another product similar to me that is available in the market. So the market survey and the prior art search is a key component for you uh, uh, to uh, to complete before you go for any startup. So once you have an idea, you have to look into the IP market, whether such ideas are already in market or already in the patent filing stage. So only after your after you confirm this criteria, you can go for your product and other things. You can start, and once you complete your product, there is when you're going for a patent, usually the startups they'll go for a patent. They will not prefer copyright or trademarks or designs. They'll go for a patent. So I'm telling this in sense of the patent invention. So when you have an invention, there are two types of applications that can be filed in patent office. The one we call it as your provisional application, and the next is your complete specification. So what is the difference between these two? Is like when you go for a complete specification, your invention is almost complete. You have the entire formulation or the product is with you, and you're disclosing the product in your application. That is your complete specification. Whereas the first type of application, what we call it as provisional, like a provisional certificate. What does it mean? It says that you're provisionally you're qualified for this course, but the degree will be your final proof to show that you have been qualified. So like that, when you have a development in your research, in your invention, even if you have completed 50 to 60% of your invention and you are pretty sure that I will complete this in the next 6 to 1 year, then you can file a provisional application. And if you still feel that my competitors are also working on a similar field and I want to be the first person to go for a patent application, then you can go for this provisional filing. This provisional filing, the characteristics of the provisional filing is that you need not disclose the entire invention of your research. You can just say that I have done this invention, and you can. There is a segment called claims in patent. So this claim is an important factor that decides on your patentability. So in claim, you can state that this is the invention and these are the things that I've done for this invention. So you need not disclose the entire invention that has happened. So this provisional application stands for 1 year. So you have to file a complete specification before 1 year. So this 1 year you will have an incubation period for you to work on your invention, complete your invention, and submit your complete specification. The idea here is most of your leading pharmaceutical companies, what they do is they invent something in one country, they file the patent in different countries. So here a concept comes, we call it as priority date. So your priority date is the date where you first file an application. Say I am filing an application in India today, whereas tomorrow I'm filing an application in US. Still, this US will have the priority date of that patent today because I have already filed the same patent in India. So the priority date is the nation where you file your patent first. That date will be considered as your priority date. So you have one provisional application now. Then you will automatically will be taken the privilege of your priority date, and that is the most important thing you have to look into. I think as far as startups concerned, students have to get into the patent laws. They need to know what are the provisions that are available for startups, and what are the patent applications, and for what I can really go for a patent, and for what I cannot go for a patent. And these startups, they can have a tie-up with an attorney and patent attorney, so that they will guide them accordingly. They will take their patent oriented, IPR oriented, they will take care of their IPR oriented segments. There are a few registered patent attorneys, we call them as patent agents. So we can have a patent agent fixed to your startup, and they will take care of all your issues. So I think these are the points that has been noted for startups right now. And for the later stages of a startup, there's different criteria that will of course will take another session. Maybe I will, if I have time in future, I will cover this aspect also.
Okay, sir. Okay, sir. Thank you very much, sir, for your information.
Thank you, ma'am. And thank you, ma'am. Is there any other questions?
Any other queries? Sir, whether the bioactive compounds can be get patented, sir?
When you say it as a bioactive compound, ma'am, the type of patent you go is very important, ma'am. Like we say, we usually categorize patents into a process patent and a product patent. So your claim, it has to say that the process that you have done is novel, or the product that you have done is novel. So you cannot say, I have isolated this bioactive compound, so that is not patentable. They will give a patent to a process, or they will give a patent to a product. So the product should be novel. Say when you're going for a new compound, yes, you can try, but still your inventive step will come into account, where you cannot stay the simple steps like using the column chromatography and using the HPLC, I come up with this compound. So they will say that where is the inventive step. So you have to take care of that, where you have to say an inventive step in your process of that compound isolation. If we can do this, I think getting a patent is very much easier.
Okay, sir. Thank you, sir. Okay, now I request Dr. K. Narayan Sami, sir, to propose the vote of thanks. Sir, please.
Good evening to all the participants. So I take this opportunity to propose vote of thanks today for this wonderful workshop. So this workshop has been organized by the Research and Development Cell and the Institutions Innovation Council of our college. So first of all, I would like to express my gratitude to our management for providing all the facilities and the permission to conduct this workshop. Then I would like to extend my heartfelt thanks to our principal, Dr. M. Ilangovan, who presided over this program. He is always with us in doing all these kind of activities in our college. So I thank him on behalf of every one of us. Thank you, sir. Then I would like to express my thanks to our resource person of this today's workshop, Dr. L. Hari Prasad, IPR cell coordinator, assistant professor of biochemistry, Department of Biochemistry, Karpagam Academy of Higher Education, Coimbatore. So your talk was very nice, sir. So on behalf of every one of us, I would like to express my thanks to him. Thank you, sir.
Thank you, sir. Thank you. Thanks a lot.
Then I would like to express my thanks to the research and development cell members, the conveners of that cell. Then the convener and the members of the ICC, that is Institutions Innovation Council of our college, for organizing such a wonderful workshop. I thank every one of them. Then the last one, but not the least, I would like to extend my thanks to all the participants who have actively participated in this program for the last 2 hours. So I thank each and every one of them. So thank you very much for the opportunity given to me. Thank you. Thank you. Thank you one and all.
Thank you. Thank you.
So thank you all. Kindly fill the feedback form. You will be getting the certificate within this week. Thank you.